During DDD appeals, often the state will try to say that an IEP does not support the arguments for DDD eligibility, which is odd because certainly they'll use it either way that they can get it. They always ask for the IEP, and if the IEP is not supportive of the limitations, the functional limitations, or the diagnosis, as a matter of fact, then they use it against the parents and the child. If, however, it says that it does support the arguments, then they say that that's not a valid piece of documentation because the IEP has to only really do with education. So they try to use it either way. The trick is that you have to do it backwards either way. So if there's not enough support for a diagnosis of autism, you have to explain, or maybe you do it on cross-examination, that the person arguing that there is not a diagnosis of autism set forth in the IEP, that's not the place for it. You can be eligible under multiple categories, and it doesn't always have to be autism, and autism doesn't even have to be the first one, even if a child is autistic. There could be different reasons that the primary diagnosis is something other than autism, even if a child has autism. So you need to educate the judge and maybe do it through cross-examination that a diagnosis for educational eligibility does not have to be autism, but the child could still have autism. It just opens the door so that the child can have those services. And there could be a multitude of reasons why autism isn't the primary diagnosis. The same way, sometimes I will use an IEP and say, look, the primary eligibility is autism, and they'll try to argue it the other way, saying, well, that's just for educational purposes. So you got to use it both ways, and you have to be ready to argue it both ways depending on what the IEP says. But often, somewhere in the IEP, it should suggest some of the criteria of autism, and you can try to point that out. But that should not be the sole basis for denying eligibility at any